Well, then me and you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork? How am I going to get a fair trial here?
You are violating my constitutional rights according to 42 U.S.C. 1983. And if you do not dismiss this case and you continue forward, I will be suing all of you in individual and official capacity for violation and knowingly depriving me of my constitutional rights under the color of the law.
Well, recuse yourself, because you're not doing it. You're not doing it.
And there's no basis for me to recuse myself.
Is this being recorded?
If you want to file a motion for me to recuse myself, then I will deal with that under Rule 10, and then I will.
I'm familiar with all the rules, y'all.
You don't need to convince me of anything on that issue. What I'm telling you is I'm agreeing with you, but the state of Kansas, for some reason, has a different opinion, and I think they're wrong. I'm just telling you, you ought to probably reach out and try to speak to them further yourself.
And then I don't mean to interrupt you, sir, but I have to. I'm going to just go ahead and say right now here on record, I'm appearing especially, not generally, and without a verified injured party and without proof of your assumed jurisdiction under administrative legislative statutes and or color of the law.
Different motions, and I want to address those motions with you. If you want to come to the podium, since you are representing yourself, first of all, let me advise you that in April of this year, you sent a notice stating it was to the judge of record, stating that on the 15th day of April 2025, I have some concerns that I wish to speak to you about before I file papers in your court. I'm letting you know this isn't a request for advice. It concerns actions by your staff of the courts and yourself. With the utmost respect, I write this ex parte letter. If we can meet in private, I will. If I can't meet in private, I'll file it publicly and the order will be noticed. I could not speak with you privately because of the rules of conduct for judges. So the first notice or first motion that you have filed has been a request for a criminal record, and states that you're requesting the courts to move the state to furnish the defendant with a copy of a prior criminal record per Rule 16 of Discovery and Inspection, Rules of Criminal Procedure. If I understand correctly, you're asking for a copy of your criminal record?
Yes, all them requests. The motion discovery is supposed to provide all that anyway, so that is summing up half the motions. I mistakenly filed them separately.
That's fine.
Some of them.
You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself. So I'm going to order that all of the evidence in Mr. Vaughn's case needs to be put into written form, hard copies, and he needs to be provided with that.
Judge, the problem with that is going to be that there are videos from his arrest. One of his charges is retaliation for past action. And so there are videos from the officers in the jail at that time. And that's going to be one of the largest problems in providing that to him.
No, sir. That's not a problem. I filed a civil suit years ago. They provided me with the DVD, and that was my issue to deal with after that. And they allowed me to go into the office privately, to view my own case, to fight my own case before, so that is not an issue.
Sounds like he's got it solved.
Okay.
You provide him with a DVD or a video on a compact disc, he'll access it as he needs to at the jail.
Okay.
All right, when is this going to be? Because I've been doing some of this since 2021. I'm tired of coming here looking at y'all. Like, this is going on for a minute. This is getting ridiculous. This is my first. I still ain't got a motion yet.
A motion?
I ain't got a motion yet. All the attorneys I had, all the public defenders I've had, nobody have provided me with nothing yet.
Okay. Well, I'm going to deal with all of that today, because you're going to get written discovery. You're going to get a copy of any videos so that you can look at them yourself. We'll have it within.
Ben, you should have it today.
We'll have it within 10 days. You have a second motion, which is a motion to remove your counsel. You want to represent yourself, and I've granted you that opportunity. I've also appointed Mr. Spratt to assist you in representing yourself. you don't understand, I assume, the rules of evidence and the rules of criminal procedure fully as if you had been to law school. So having a lawyer who can assist you in making objections to evidence, for example, and things that's the reason that you have elbow counsel. Why do you want to dismiss your elbow counsel or your assistant
For
counsel?
one, the court doesn't respect the fact I'm pro se. They prefer to talk to him instead of to me. And anything should come through me first. He's an assistant. For two, Mr. Spratt, since December, has had a sickness or illness going on, which is on record in Humphreys County Jail, where he never could show up out there. I called 2 or 3 times. I should have had the motion discovery he just handed me.
All right, well, that's part of life, that people have illnesses and sickness. I am going.
Not for a month and a half. I'm sorry, sir. Excuse me, but not for a month and a half. I mean, he ain't able to help me.
Well, I'm of the opinion that Mr. Spratt is able to help you with this because he is only elbow counsel. You're representing yourself. I will order that the discovery and motions that are filed in his court need to be sent directly to Mr. Vaughn rather than a copy to Mr. Spratt directly to Mr. Vaughn so that he gets a copy without having to wait for his co-counsel. So I'm denying at this time your motion to remove counsel because I think it's important for you to have someone at trial to help you with that.
Well, what about the fact that he couldn't even come to Waverly? How are you going to get to Decatur?
When I did finally feel better and go to see Mr. Vaughn, he had been transported to West Tennessee, and I just simply have not been able to make it down there with my schedule.
I am denying your motion to discharge Mr. Spratt from being your elbow counsel for the reasons I've stated on the record. Another motion you have filed is a demand for speedy trial. Your trial date is in September, which is the next term of court that I have. It's available, and for that reason, I believe that complies with the request for speedy trial that was filed. It is the first available date that we can put into play. The remaining motions that you have filed are all motions for discovery, which I think you had mentioned before, and I think we've now addressed that.
Excuse me, sir.
Docket, so that we'll go to trial. And let me address this. You filed a motion to recuse, notice of recusal or request for the master clerk, and you're asking to recuse or to somehow recuse the clerk of the court, and there is no basis that you have no standing under the law to ask this court to disqualify the clerk of the court. I understand your reasons for why you say that, and I have addressed the problems that you're saying you've had thus far with receiving copies of things, and that's going to be mailed directly to you. The court file will have it reflected that you are to receive all of those as lead counsel in your case, and I am not of the opinion that you have a basis in law or in fact to remove or ask for a recusal of the circuit court clerk, so that motion is denied. In addition to that, you had a motion to recuse the court recorder. Again, I have no idea why. I don't find any basis for removal or that you have standing to remove the court reporter. She worked for me, and under that basis, I don't find there's any reason.
Well, then me and you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork? How am I going to get a fair trial here?
You're going to get a fair trial because you're going to be tried according to the law and the facts, and a jury of impartial people who know nothing about your case will make the decision.
So if I want to make an appeal and she ain't recording it, how are we going to do that?
She will be recording it if it is a felony case. There are certain times when the cases are not recorded, or if we're on break, it's not recorded, but.
Well, we wasn't on break because, look, I just walked out the courtroom and I said something after we went on break. You said omitted. And she said, well, I ain't got to omit it. She said I wasn't recording no way. So how can I appeal something if y'all taking it out of the record without me being present during the proceedings?
Well, first of all, I don't recall any such thing that
Well,
you're
go back and look at the
referring to.
video.
I'm not required to go back and look at the video, Mr. Vaughn. I'm required to make decisions based upon whether or not you have standing for the motions that you filed. In my opinion, you don't have any standing to ask this court to discharge our clerk, our court reporter or our clerk. And for that reason, I'm denying those two motions.
Well, recuse yourself because you're not doing it. You're not doing it.
And there's no basis for me to recuse myself.
Is this being recorded?
If you want to file a motion for me to recuse myself, then I will deal with that under Rule 10, and then I will address
I'm familiar
that.
with all the rules. Y'all sit me in jail long enough, best believe I read them.
All right. Anything else?
No, that's all.
All right. Thank you.
Briefly, if I may, when would Mr. Vaughn be transported up for this trial? Because the trial that
I
I
done put
mentioned,
in 3 motions for that. That ain't get heard neither.
I'm just asking the court, because the trial that I have in Davidson County that I mentioned in the earlier matter is the first of that week. We do not expect that to be a 5-day trial. I'm wondering if I'd be able to meet with him to strategize at all for this trial beforehand, other than Thursday, the 18th.
We can have him, we can order that he be transported earlier if you just tell me when you want. The 17th?
No, I like my cigarettes where I'm at. I don't need his assistance.
Okay, well, that'd be fine, Your Honor.
That's fine with us.
Yes, sir.
All right, thank you, Mr. Vaughn. You step back.
Today, Mia, and hey, Judge Khan. Hi.
Still the same old charming self. Okay, good afternoon, good morning.
I'm really grateful to see you. You don't even, it's been crazy. I've been looking forward to this moment.
I imagine you are. We've been tracking you as to where you've been, so we knew where you were in Jeffco for a while.
Great.
Yeah.
I was worried. I'm like, why am I not trying? Yeah. Anyways, health.
Okay,
Yeah.
here.
I'm grateful to see you guys.
Okay. So
Ms. Colleen,
I was able to speak with Mr. Cardona. He is inclined to take the plea. However, before he does that, he wanted me to inquire, since he's been in custody since April 3rd, if he would be getting credit from that date.
So Ms. Talene, the credit that he would get would be for the time that he's been in custody in Boulder, not for the time he's been in Jeffco.
and that's only for a day. I think he's only been here for a
Yeah.
day.
So in other words, no.
Okay.
No dice.
So then I think he's probably not going to end up taking that deal. I mean, I will say he still has some other stuff that he's got to figure out. So
I'm time served on the other stuff because it's since they entered a writ on April 10th. So I'm time served on that. And I'd be willing to like negotiate. Like, look, I've been through so much. My mom is stealing my fucking dog, which you guys all
Careful with the language. Careful with the language.
You all know that she's mine. And so I had to take a plea, and I'm just so done with all of it. I'm ready to take a plea, whatever. I'm over it. I've just done 122 days of my life for something that I did not do. And so if you guys could help me to help you to help us, I'm definitely down. I'm just not going to sit in here for 45 more days for mostly garbage charges. Like prohibited item. Like, no. I'll bail out and we'll go to trial if we have to, but I would much rather not have to have loose ends, and I would much rather deal with it than have to continue prolonging it. So if we can come to an agreement that's not
So
gonna-
let me ask.
I can't be part of that discussion. So let's
Yeah,
pause
I was
for a
going to say,
moment.
so let me ask you this, Julio. What if we brought you back next Wednesday and I could speak with Miss Keller about some different options for you?
That would be great. If in the meantime, as I said, I'm time served on my other ones, and so
I mean,
I'll
you'd be able to bond out still. If you can post your bonds, you'd be able to bond out. But
according to the jail, there's a $50 cash only bond. And since like I was trying to come to court last time, I got arrested 2 days after you signed the release or PR bond on Sunday, the 28th, I would have been here, but I got arrested. So if you would be willing to reinstate that PR bond on that, I'd be grateful. I'm still held on a $2,000 bond until I go to court, but I don't want to be stuck in here. If I post a $2,000 one, which I guess, right, if I post a $2,000 one, I don't want to be held here on a $50 more thing. So if you would be willing to redo what you did on Sunday, March 28th by signing a PR bail and reissuing that, I'd be grateful. I would have been there, but I was in jail and I couldn't be there. If you'd be willing to do that, I'd be grateful. If not, I can probably try to come up with a $50 bond that it's currently $50 cash only.
Is that what they're telling you at the jail? Is that that's the only cash bond that you have to post? The others are PR bonds?
No, well, so originally when I first got here, before I got here, I was told I had 4 $200 cash or surety bails. Meaning the 10 cent, like basically $80. But then I got here and they're now telling me that there's a $150 cash only for my municipal cases, but no PR bonds. So I basically have to post a $2,000 cash or surety bail and then a $50 cash only bail. I do have my family working on the cash or surety $2,000 bail. But that apparently they didn't do the 10% option or whatever, so they can't just go to touchpaydirect.com and do it like they usually would. My mom's obviously doing the other thing, so the only person I have that is family to help is over 10 hours away and not able to be here. So they're trying to do it online and trying to facilitate to that. But even once they accomplish that, then I'd still be held here on the $50 cash only bail until I could come up with that. It's like, so if just originally on March 26th of this year, I took a plea bargain and then I was still held here to come to your court. And then on Sunday, the 28th, I'm assuming it was you, signed the approval for a PR bail in my municipal cases. And I was released on Sunday, the 28th, and I was arrested again on the 3rd. So it wasn't that I was trying, when I'm in cuffs, I can't show up. You know what I mean? And I did have my family text Ashley, try to reach out to Ashley and everybody to try to communicate so that you would be aware that I wasn't trying to skip out on you. And that it's been a crazy few months.
I know that 2023 4906 is not eligible for a PR bond. That's one of the $200 cash bonds. And at this juncture, not today, I'm not willing to convert those to PR bonds. They would maintain those. That one is a cash bond. By statute, there are some that have to be converted to PR bonds when a defendant requests that. So I will be looking at each of those to make sure that I'm complying with the statute, because what defendant has done now is made a formal request for a PR bond. But I know 2023 4906 has a misdemeanor state counterpart, and that one would remain. So we can do this now, or what we can do is hold off, like Ms. Talene was saying, and come back on Wednesday.
And then I might be able to talk to Miss Keller and see if we could work out some disposition. I don't know. We may or may not, and then we could deal with the bonds as well. But
okay. Even if we could get them to converted to the cash or surety 10% thing, I'd be willing to post a bond. I have no problem trying to post.
Maybe that's what you're thinking, because our cash bonds also come with an alternative of a surety bond. The surety bond is $500. So maybe what you're thinking is that you have to pay $50 to a surety, yeah, and then that's your 10%. But yeah, our cash bond right now is $200. A surety bond would be $500 on that case. So that's why you might be thinking all you have to do is come up with $50 to get a surety to do it. But that's not something that I have control over. That's obviously between you and a surety, a bonds person. So
whatever happened to the 10% thing that you guys used to do, to where my dad could just jump on the...
That's not us. That's what I'm saying. That's something that's done with a bonds person. And there may be something where there's an online process. Ms. Talene may know more about that than I do. I've never interacted with the online bond posting process with the surety, but that's a separate person who's doing that, or a company that's giving you, posting the bond on your behalf based on your dad or you giving them a certain percentage of the amount that's owed, and then them being responsible for the rest. That's how the surety bond works. Does that make sense to you, Mr. Cardona?
Yeah, I'm just trying to, because every other time I've bonded out on every single case you're talking about right now, including the one that you say is not PRable, and I've been released on that charge on PR several times. So I'm just confused as to why it's suddenly different.
Well, right now you have a cash bond that I've imposed And it's because there's been failures to appear. Obviously, that's why I've made it a cash bond and am not converting it to a PR bond. I am going to follow the state law with respect to the ones that you're entitled to have PR bonds, and some charges you are automatic PR bonds. The more serious ones are not. The ones that are less serious, like you mentioned, a tent or a camping charge, those are automatically eligible for PR bond. That's probably why what you remember most is most of your cases have been eligible for PR bonds because they were automatically eligible for
So
some.
I mean, like, you released me on those charges, even the ones that you say. And again, it wasn't that I didn't appear; it's that I was being held against my will in another county's jail. So if you could reconsider that, I'd be grateful, because this.
I'm not going to reconsider it today because I don't think any party has the opportunity to go through all of the circumstances of each of these. And given that Ms. Talene,
the sovereign citizen style language gives the defendant a sense of control, but the court is focused on attendance history, bond risk, and procedure. That mismatch feels empowering emotionally, yet it weakens the only arguments that could actually lower custody risk.
is in the mindset to see you Wednesday, and that you have another case that's pending with the bond for this state. Let's reset your case. I'm happy to reset it. If everybody wants to remain on, I'll pause and I'll look through every single one of these cases to see which ones are eligible, but it may take me quite a bit of time to do that.
I would be grateful, but.
All right, let me just, someone was trying to speak. Who was that? Was it Ms. Keller or Ms. Fernanda?
Excuse me, Your Honor, it was me, Ms. Biddingcourt. Mr. Cardona does have a court appearance with Boulder County on the 13th of August, so I believe he's still being held until then.
Right, but I have the bail for that. I'm gonna post bail on that, and or also that court date on the 13th. I'm already time served, already, according to the deal that they're gonna do on the 13th.
Let's pause, and then I'm gonna look through the files, see what I have here, and then it may take me a few minutes because I got to look through each one of them and see which ones are automatic PR bonds and then which ones are not.
I know there's a lot. Thank you very much for working with me, guys.
Okay, I'm going off camera for a moment.
Oh my goodness. Oh, it's still waiting. They're gonna come back. Appreciate you. He said it might take a while because I got like fucking 21 cases he's gotta go look at. So I don't know if everybody can still hear me or not, but one thing that I know that I've become aware of that I wasn't prior is 90% of these charges are what's called administrative legislative statutes, which is known as color of the law, and that is illegal to practice. And if it continues forward, I will be giving statutory official notice to everybody of the 1983 federal lawsuit that I will be bringing into the court. If this court does continue forward under administrative legislative statutes without an verified injured party and under their assumed jurisdiction, I will be suing. And I will give everybody statutory notice of intent to sue both individually and to official capacity as soon as I get out. Or we could just settle it. Seems like it'd be a lot easier for everybody. There must be a verified injured party, and you must prove your jurisdictional means to do these things, none of which have occurred. I am hereby asserting my rights to those things, assuming that everybody can hear me. And it's being recorded, so it's on record regardless. Yeah, and so it's still going. I'm still waiting. I'll let you know when I'm done. Hey.
Okay, we can go back on the record. And I did hear what defendant had to say with respect to his statutory rights that he believes he has. I'm not going to address those issues with him. That's certainly his right, and he can consult with his own attorney as to how he wants to proceed with respect to that. I'm just here to at this point to address the request for PR bonds. There are many cases for which we have not issued warrants at all.
Okay.
And then there are 5 cases for which warrants were issued, 4 of which were cleared by the Jefferson County Jail. One, for whatever reason, hasn't yet been cleared, but it will be cleared. Of those 5 cases, Case number 2023-4906 is the most serious. It's a threatening bodily injury charge. That has a $200 cash bond or a $500 surety bond currently authorized. It does have a state counterpart. I did note that the defendant had failed to appear more than once. Many times he would call after court and get his case rescheduled, but there were two separate failures to appear in that particular case. And one, the most recent was March 11th of 2025. And then ultimately we allowed PR bonds on those, I believe. But in this case, now that there are cash or surety bonds in place, I'm going to maintain that cash or surety bond on case number 2023-4906. Case number 2024-5724 is an obstructing government operations charge. There's a prohibited items. That's PR bond, but the obstructive government operations is not a mandatory PR bond because it does have a misdemeanor state counterpart. That will remain at a $200 cash bond or a $500 cash or surety bond. Case number 2024-5633. This is an improper care of animals charge, which does have a misdemeanor state counterpart. That will remain at a $200 cash or $500 surety bond. Case number 2024-5730 is an obstructing government operations charge. That does have a misdemeanor state counterpart. That will remain a $200 cash bond or $500 surety bond. And then case number 2023-5211 is an obstructing government operations charge, which is has a misdemeanor state counterpart. That will remain as a $200 cash bond or $500 surety bond. All the other cases we have not issued warrants for, so that I'm not issuing warrants on those at all. If in fact you are released from custody on posting bonds, those cases will remain active and you can come to court on those. But I'm not going to issue warrants because I don't need to unnecessarily burden the system with warrants.
Just as these ones currently are, because I was in custody when you issued the warrants.
That's not actually true. You were not in custody on March 11th. I issued those warrants, those cash or surety bond warrants on March 11th.
Then why would you release me on March 28th?
You were ultimately released I think you were taken, not released, but taken to Jefferson County.
No, I was released. I was
released. Okay, then if you were released, then you were released on some kind of bond that you posted.
I was released on a PR bail on these charges, which is why I was asking you to please redo that, because the only reason I didn't show up was because I got arrested by Glenwood Springs or Garfield County and then transported to Jefferson County. That seems I was in custody by another jail after being released on PR bond on all these same ones. And
I hear what you are. I hear what you are arguing. It is not. It's incumbent on the defendant to appear in court on their court date. There can be all kinds of explanations for why someone doesn't appear, but it's not the court's responsibility to simply say, well, because you got arrested by another jurisdiction, you're exempt from having to appear in our court. You had an obligation to appear and you did not appear.
I tried to, they wouldn't bring me. There's nothing I can do about that.
Right. Well, we'll right now, I'm maintaining those cash bonds in place. There won't be any other warrants issued on the other cases.
Okay, well, I'm going to go, and I don't mean to interrupt you, sir, but I have to. I'm going to just go ahead and say right now here on record, I'm appearing especially, not generally, and without a verified injured party and without proof of your assumed jurisdiction under administrative legislative statutes and or color of the law, you are violating my constitutional rights according to 42 USC 1983. And if you do not dismiss this case and you continue forward, I will be suing all of you in individual and official capacity for violation and knowingly depriving me of my constitutional rights under the color of the law.
Okay.
If you want to settle it, I'm down to settle it. I'm not.
You can't talk to me about settlement with me present. You can talk to the prosecutor with your lawyer present for that, but I can't negotiate with you because I'm not on the other side of the case. That's between you and the prosecution.
You are the judge, though, and you do have the jurisdictional ability and legislative power to dismiss this before getting sued under 42 USC 1983, which is I'm
not dismissing it, nor do I believe I actually have the authority to dismiss the case where there's probable cause for the charge.
All right.
The authority to request dismissal comes from the prosecutor's office. Now, let's talk about procedural posture where we're at today. So, Ms. Talene, do you want to come back on Monday, or do you want to come back on Wednesday? We can do it either way. It's up to you.
Mr. Cardona, what do you want to do?
I mean, Monday would obviously be the best. I'm also going to contact my other attorney, which is Catherine Spangler, to get the other court date moved up. I'm time served on the other one. I would be time served on this, or you guys can all get sued. I don't really care. But I would prefer Monday. That would be the best. But I also want to give you time, and I'm speaking like me. I'm not trying to be a hard ass. I don't care. I've been getting fucked from every. Excuse me. I've been getting screwed from every angle without just cause. I've learned a lot of my rights, and I will be exercising them. But again, I would much rather not deal with the fight. Just as I know you would like to not deal with the fight. If we could please come to some form of agreement of time served for I've been in jail for 122 days for something I didn't do.
I'm going to pause for now. I'm going to pause now because I think you're having discussions I don't want to hear because I'm not legally allowed to hear them. So if we'll reset. Let's reset for Monday.
Yeah, we can reset for Monday, and if I can't do anything on Monday, we'll just reset you again.
Right. So another question I have. So you said they're $500 cash, or if it's a surety, it's $500, right?
That's right.
And so then somebody has to pay a bondsman 10% of that?
That's up to the bonds person. I can't speak for them, but a lot of times they will allow, less than the full amount in order to be responsible for the bond. But it's not something I can commit to.
So yeah,
the jail has all of these bonds, so they know what the warrants are and what the bond amounts are. Whatever they determine for you to post to be released, they will do that and accept the payments from you as they deem appropriate, given the documentation that we've given to them.
According to them, less than an hour ago, those four $200 ones.
So just go talk to the jail about it then and see what you can do, because they have
shut up, stop.
Yeah.
All right.
They have the well, no, I'm just saying they have the information. There's nothing else that Judge Kahn can do for you. Now it seems like it's going to be between you and the jail and potentially a bondsman.
That's right. Okay. Right. We'll see you.
And we'll see you on Monday. Yeah.
What time do you guys know?
10:30.
Okay. All right. Thank you. Have a great weekend, everybody. And
see you Monday.
Mia, please work with. Look,
lady,
I'm not about.
Okay, I'll talk
I'm
to Ms.
done
Keller
resisting.
about it.
Another thing I wanted to say is I've been a difficult fucking prick a little bit in the past. I was going through a lot, and I'm please work with me. And
I will speak with Ms. Keller. Okay.
Okay. Thank you.
All right. Let the officer know that we're ready to go.
Bye, Con.
All right. Take care.
You too.
Fernanda, why don't you come on back? We can talk about how we reset all these cases.
Sounds good, Judge.
Now then, let's take up Abel Estrada Jr. Mr. Estrada, you'll need to start your audio and your video.
Yeah.
Okay, all right. We are on the record in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Assistant County Attorney Paul E. Dean for the state. The defendant appears in person and pro se. The defendant, let's see, this first appearance back in October of 24. After being dismissed and refiled from municipal court and some failures to appear, then we had a bench trial February 14th, 2025, and the defendant was found guilty and ordered to pay $108 in court costs and the scheduled fine, with the court specifically ordering that if he appeals, an appeal bond set at the amount of cost and fines had to be paid before or at the time of the appeal. We had a peer review February 28th, 2025. Somehow he was attempting and made some efforts to file the appeal without a bond. He had gone through a couple of attorneys and then ended up representing himself.
Also determine whether he's actually properly docketed it. He's told us that he has. He's told us that he's talked to people in the clerk's office and that it's taken care of. But to date, there is not one piece of paperwork in my file that shows anything from the Court of Appeals, which we would have received electronic notification. Should have received notification of the docketing, should have received notification of any motion that he filed to waive for the Court of Appeals to waive the appeal bond. I believe you referenced something of that nature at that time. I might be mistaken on that.
That's why I was walking through the history. That's what I'm finding too. When he was here May 9th, 2025, another payer peer review. Let's see. The defendant said he is outside the jurisdiction of this magistrate as he is strictly under the appeal court authority, that he had an appeal court case number. So I could not enforce the order for appeal bond or sentence, basically. So, have you paid? It does, Mr. Estrada, did you pay the fine ordered of $158? The court file says you haven't. Looks like you had 108 court costs and a $50 fine for illegally display of license plate or not display.
Your Honor, I take that back. I think my office has finally found something.
Okay.
It just has not, the paperwork has not hit the file. Looks like transcript's been completed. Oh, well, table of, okay, we did receive, apologize, notice, court docketing notice, appellate court docketing notice. So I think actually at this point in time with that, and that, I don't know why it took so long to get to us, but with that, we can remove this case from this docket and we will take care of it at the Court of Appeals.
Let me see if I find everything. Okay, suspension.
I will have my office, I'm going to ask them to file that a record in this, at the trial court level. That way we have that in there. Judge, you don't see, you can't see that from your end?
Well, let me see. I'm seeing the transcripts.
And we did receive a letter. That's probably an emailed letter, but it is appellate court case number 128,986.
Okay.
So
okay, I did find it. Thank you.
Current jurisdiction at this point in time from the district court.
Okay.
So.
All right. Well, we will just wait and see what the Court of Appeals thinks about your conviction, and I guess they're not going to enforce the order to pay the bond. So if the Court of Appeals decides that piece of paper was sufficient for requirements of tag violations, they'll let you go and it'll be over. But if they find that the conviction should be sustained, that that piece of cardboard that you bought from someone was not a legal tag, then they'll let us know and you'll still owe that money. Now, what I'm wondering, Mr. Dean, I think we might need to look at what appears to be some suspensions on his record for not payment, because if those suspensions for non-payment were filed by our county clerk or our district clerk after the appeal was docketed, those may need to be revisited. If they were done by the Department of Revenue in Topeka at any point in time, I can't overrule or override them. You have any thoughts on that?
Your Honor, I don't know who would have initiated that, because the case had been on continuance. I mean, I think the order's quite clear in this case. They would have received that notice of appeal. So I guess we just need to reach out to the clerk's office. If Missy, if you could reach out to them on that, maybe we could find out an answer to that. I would agree there should be no suspensions as a base from this case, but the Court of Appeals has indicated on the letter that I just saw that they considered it properly, timely docketed. The appeal is timely filed, so there should be no suspensions as a result of this matter until we're back here or the Court of Appeals says that it's overturned.
But Mr. Estrada, you might be mindful and check your driver's license and see if the status is suspended, because it could cause you some grief if you're out there driving around with a suspended license, even though we may be able to clarify it eventually and correct if it needs correct it eventually, but it could cause some headache for both you and for this court and the prosecutor having to come back and visit that. So,
and Mr. Estrada, why I've asked the judge's administrative assistant to check with the clerk's office because she's right down the hall from them. I think it would probably also behoove you to contact the Kansas Department of Motor Vehicles and question them about that status. You may find it easier to send them a fax, because they're quite difficult to get to get a hold of anybody by phone. In any event, that's all I have, Your Honor.
Okay.
Well, I did get 3 different letters saying that I needed to pay, and I called them and I told them that I'm already in the appellate court, and there's no reason why I should be suspended. Is this gonna cause me any more problems? Is there something that I can call you back so you can confirm to whoever I'm talking to?
You don't need to convince me of anything on that issue. What I'm telling you is I'm agreeing with you, but the state of Kansas, for some reason, has a different opinion, and I think they're wrong. I'm just telling you, you ought to probably reach out and try to speak to them further yourself. Perhaps send them a copy of the appellate court docketing statement, things of that nature. Maybe that'll help clear it up for them.
Okay.
All right, Your Honor. Can we take a short break before we get into our 10 o'clock? I don't have anything further.
All right. We're just going to hold tight until the appeal is done. I'm not going to set another case this time, Mr. Estrada. You're excused from today's hearings.
Judge, could we take a break before we get that 10 o'clock going? Thank you.
We'll take a 15-minute break and then we'll get started again.
Across all 3 hearings, the pattern is the same. People often believe the case is about respect, jurisdiction, paperwork tricks, or proving a point. Courts usually see something narrower: compliance, deadlines, appearance history, payment orders, and whether rules were followed. In the first case, the defendant wanted control of his own defense and challenged nearly everyone in the room. But self-representation creates a trap. Once you reject counsel, mistakes become your own responsibility. Every motion denied narrows options. Every conflict with the bench can distract from trial preparation. In the second case, threats of lawsuits and phrases like color of law, special appearance, or demanding a verified injured party sound forceful online. But bond decisions were tied to failures to appear and charge level. The court kept returning to measurable risk, not slogans. That is where many sovereign citizen arguments collapse. They answer a different question than the judge is deciding. In the third case, something important happened quietly. Procedure mattered more than personality. Once the appeal record was confirmed, the lower court stepped back. That hearing shows the opposite lesson. Real leverage usually comes from filed documents, preserved rights, and timing, not confrontation. Small choices become large consequences in court. Missing dates becomes higher bond. Rejecting useful help becomes weaker defense. Filing correctly can pause enforcement. The loudest argument in the room is rarely the strongest one. Sometimes the outcome turns on the quiet paperwork nobody notices.